Hello everyone, we are going to discuss another civics chapter here, the judiciary. The judiciary of a country is a system of courts that interprets and applies laws in the state or country. The primary responsibility of the judiciary is to ensure justice under equal law, irrespective of status, wealth, religion, and gender. This we have divided in two parts. In part 1, we are going to learn about the Indian judiciary system, the composition of the Supreme Court, qualification and appointment of the Supreme Court judges, tenure, removal, and the power and functions of the Supreme Court. We have a single integrated judiciary for the Union and the states. While the legislature and the executive in India are organized on federal lines, that is at two levels, one at the center and the other in the states. The Constitution has provided for the setting up of a single integrated system of courts to administer both union and state laws. There are no separate laws and one single criminal and civil system operates throughout the countries. The judiciary forms the third branch of the government, the other two being legislature, which is responsible for creating laws, and executive, which is responsible for enforcing laws. The Indian judicial system derives its powers from the current legal framework laid down by the Indian Constitution. The judiciary in India consists of three levels. At the top of the judiciary is the Supreme Court, then came to High Courts, and then the subordinate courts. The Indian judiciary is organized in hierarchical form, with the Supreme Court at its apex. Below the Supreme Court are the High Courts in the states. There are many subordinate courts under the High Courts. Subordinate courts include the district and the session courts, the provincial courts, and the Nyaya Panchayats. Each court is headed by judges with varying powers depending on the level of jurisdiction. The judiciary is independent of the legislature and the executive. The Supreme Court has the highest judicial authority in India. It is the third branch of the central government. It is located in Delhi. The responsibility for the interpretation of the Constitution and the laws made by the legislature lies with the Supreme Court. Any law or order passed by it is binding on all the courts within the territory of India. Here we will discuss composition and organization of the Supreme Court. The Supreme Court consists of the Chief Justice and 30 other judges. The President appoints the Chief Justice of India on the advice of Council of Ministers. The judges of the Supreme Court are also appointed by the President on the advice of both the Council of Ministers and the Chief Justice of India. Appointments are generally made on the basis of seniority and not political preferences. Here we'll move ahead to learn the qualifications of the Supreme Court judges. A judge of the Supreme Court must be a citizen of India. He must have been a judge for at least 5 years in High Court of India, or he should have been an advocate or lawyer of a High Court for at least 10 years, or he must be, in the opinion of the President, a distinguished jurist. The Chief Justice and judges of the Supreme Court serve until they complete 65 years of age. Even though they are appointed by the President, their services cannot be terminated by him or her. A judge may resign by writing to the President. Here we will discuss about the impeachment. A Supreme Court judge can only be removed on grounds of proven misbehavior, misuse of power, and incapacity. He may also be removed from his office by the President, but it can be done only by an address of each house of the Parliament to the President and by passing a resolution by both the House with a 2/3 majority. The judge can be removed only after the President gives order for removal. The judges of the Supreme Court cannot practice at any of the courts of India after their retirement from office. We'll move further to learn about the powers and the functions of the Supreme Court. There are many powers and functions are there. Before that, we will learn the meaning of jurisdiction. Jurisdiction means the power that a court of law exercises to carry out judgment, to interpret laws and settle dispute. The Supreme Court has original, appellate as well as advisory and revisory jurisdiction. With this, we will learn the judicial review and court of record as well. As we are moving ahead, we'll learn first about the original jurisdiction. Original jurisdiction refer to those cases which the Supreme Court can hear and decide in the first instance. These cases cannot be moved in any other court and are directly brought before the Supreme Court. The Supreme Court has original jurisdiction over the following cases: a dispute between the Government of India and one or more states, dispute between two or more states of the Indian Union, or dispute between the Union and any state on one hand and the other states on the other hands. The Supreme Court is the highest court of appeal in our country. A court of appeal means one which may change the decision or reduce the sentence passed by the lower courts. Appeals in specific civil and criminal cases can be made to the Supreme Court against the decisions of the state high courts. Appellate jurisdiction covers three types of cases, namely constitutional, civil, and criminal cases. Advisory jurisdiction. The Supreme Court can advise the President when requested to do so on matters of law and constitution. However, such an opinion is not binding on the President. The President may seek the opinion of the Supreme Court on a question of law or fact of considerable public importance. Under this jurisdiction, disputes involving interpretation of treaties or agreements of former Indian states can also be referred to the Supreme Court for its opinion. Now we will discuss about the revisory functions. The Supreme Court under Article 137 exercises the power to review any judgment or order declared by it. This provision enables the Supreme Court to rectify any error that might have crept in this judgment or order. This is because the Supreme Court cannot allow any error in its judgment as it may prove to be harmful for the common good. The Supreme Court of India also has the power of judicial review. The Supreme Court of India has the highest responsibility of protecting and interpreting the Constitution of India. It can review any law or order passed by the central or the state governments for constitutional validity. It has the power to reject any law or its part which is found to be unconstitutional. Next, we'll move ahead for the Court of Record. The Constitution makes the Supreme Court a court of record. This means the Supreme Court decisions and judicial proceedings have evidential value and cannot be questioned by any other subordinate court. Its judgments are recorded for evidence and testimony. These are in the nature of the precedents. That means High Court and other courts are bound to give similar decisions in similar case. They cannot be challenged in any court. The court has a power to punish contempt of it. These evidences and judgments are stored as reference for future dispute. After discussing about the powers and the functions of the Supreme Court, now we'll move further to learn and discuss about writs. Writs are formal written order issued by a government entity, generally the Supreme Court and the High Courts, giving order or direction to a person to act or not to act in a particular way. Writ can be in the form of warrant, orders, and directions. There are 5 types of writs: Habeas corpus, mandamus, prohibition, certiorari, and cognovento. Now we will learn about each of the writ in detail. So we'll start first with the habeas corpus. Habeas corpus is a Latin word meaning you may have the body. The Supreme Court and a High Court can issue a writ of habeas corpus to a person who has illegally detained another person in the custody and command him or her to bring the detainee into the court to clearly explain why the person has been detained. If it is proved that the detainee has wrongly been detained, then he will be at once and unconditionally released. Next, we'll go to the mandamus, writ of mandamus. This is the Latin word mandamus mean be command. The Supreme Court and High Court can issue this writ to compel an inferior court or an official or individual to perform his duties. Now we'll move further and learn about the writ of certiorari. This term means to be informed about what is going on. By this writ, the lower court is instructed to hand over the record of a particular case to the higher court. In fact, this writ is issued when a lower court has already heard a case beyond its jurisdiction and given its judgment. The entire case file is handed over to the higher court and the judgment will be declared null. This writ is remedial in nature. Next, we are going to learn the prohibition. A writ of prohibition is issued to prevent an inferior court from hearing a matter beyond its jurisdiction. Thus, the Supreme Court and the High Court direct the inferior court to keep the limit of its own jurisdiction. In this sense, it is preventive in nature. And now last one, quo vento. Writ of quo vento. This writ is issued against a person who has wrongly occupied an office. The office must be a public office. The writ will tell the person to explain under what authority he or she is holding such office. If the court finds that the person is holding the office illegally, it will order him to vacate the office.